Who hasn't? Then we'll go back up.
So looking beyond your case, do you feel there's a point at which intellectual property protection, at which point at which the pendulum swings too far? The main point to me in Eldred was about the length of a copyright term. So in that, or just in general, in the strength, in the amount to which the copyright law favors the producers of works instead of the consumers of intellectual property, is there a point at which that balance shifts so far that science and the useful arts are no longer promoted? And if so, what do you think that point is?
Well, on the way out here, I was reading the ABA Journal of all things. It's like, how did I end up in this spot? You know, the American Bar Association Journal, and it's talking about Lessig's crushing defeat on Eldred Ashcroft, and his point that he's going to, you know, if you read his stuff, he says the only reason we lost that is because I just didn't argue it very well. So we're going to, you know, charge the hill again, and next time we'll get it right. We recognize that there are two arguments here. You know, maybe it's a self-serving interest for us because we have these copyrights to be in the position we're in. But clearly there were also 7 Supreme Court justices that are saying that it should lean this way. On the next run up the hill, does it start swinging back? I don't know. I'm just telling you, you know, this is where the status of it seems to be right now.
But in your opinion, at what point does intellectual property protection no longer promote science?
There's a balance there, and that, you know, society and individual, you know, rights are what have to be balanced, and that's what occurs in the court system every day. But, you know, just think of it, you know, law isn't just, you know, about balancing, you know, words that are in a contract, but ultimately having to balance the issues of, you know, human behavior. And when we're talking about, you know, rights of individuals versus rights of society, do we ultimately get to a point where if it's all free, it's all shared, there is no, you know, individual contribution that is recognized, how are people going to function? Are we ultimately going to see a lot of progress in the useful work in science? Or are we going to see people sitting back and going, I get nothing for this, so why am I going to contribute? It's just like if there was no grades with going to college, would you work so hard? If there was no benefit for amassing knowledge for a career beyond that, would you work so hard in school? You know, if there is no individual benefit ultimately, are you going to work so hard to pursue something? And that's what ultimately has to be balanced.
We could take one more question.
All the way back.
Thanks. Earlier you mentioned the files that you released as examples of where Linux infringed on your intellectual property, and you also mentioned that Linus himself pointed out that some of those he had written himself way, way, way back when. That kind of undermined your argument, and you lost some credibility there. And I believe an article came out last week that threw into question where some of the other ABI source came from, and if in fact it may have been even released to the world by Caldera themselves. What are your comments on that, and are you going to show better diligence in the future when you do release source code and as an example of infringement?
Let's just stick right on those files right now. Again, Linus said 2 of those files I already remember writing back in the early 90s.
I still have issues with those 2 files, by the way.
Right. We don't. We'll get to that as we go through the court system here. But what about the other 70? I mean, again, we have brought in some experts that understand Unix and Linux, and this is not Chris and I up here making this stuff up. There are very strong experts that are going to be weighing in on a witness stand that have gone through all of our property rights, and they've gone through everything on Unix and everything on Linux. Take the AT&T US or the AT&T BSD settlement agreement that govern the use of these files that we're talking about. Has anybody in here in this room seen that agreement? It's under seal, okay? So the starting point here is, as Chris said earlier, it's real easy to throw some stuff out there and say, well, this argument's gone because of that. It's real easy to go onto a website and put up a bunch of stuff as arguments. We'll be more than glad to get all of the issues on the table and basically sort everything out, and that's what we expect to do through the judicial system. Last question?
Just a quick question. What's the timetable for resolving this in the court system, and what are the implications of winning or losing the suit for your company?
The question, just for those of you watching online, is what's the timetable for resolving the court issues, and also what are the implications of winning or losing? What are the implications of winning or losing? It's probably a good last question.
Yeah. Okay. She really wants to ask one. Let's do hers first, and we'll have that as the last one. Go ahead.
Hi, I'm Erica Peterson. I'm also from MIT. I've been listening to you all evening repeat that you have no problem with developers who choose to distribute their copyrighted works under the GPL. But I have a quote here from you on December 4th where you said, SCO asserts that the GPL under which Linux is distributed violates the U.S. Constitution and the U.S. copyright and patent laws. I'm curious why you would say that.
Right. So if you take a look at, go back to the notion again, we basically would say from a voluntary standpoint, to the extent that people put this in there, then great, God bless you. When this thing moves into, see what this whole thing is, the crux of with Linux is it's the operating environment. And when the operating environment becomes standardized and there aren't choices out there for people that have to play, the operating system is a unique beast because you're not just talking about an application. You're not talking about a widget or a piece of hardware. You're talking about something that a lot of people have to play into. When you come back and basically say at the underlying level here, from a voluntary perspective, if people are putting things in there, fine. If people are putting things in there that are in violation of our rights, if they're putting our stuff in there, then we do have a big problem with that. The last question up here then I'd go to, the time frame on all of this. We filed the initial suit against IBM March of last year. We've been going through the discovery phase. There have been motions back and forth, and so we're in the discovery phase right now, and it's set to go to a Utah Federal Court jury trial on April 11th of 2005. So we're a little over a year away from having that heard in the Utah courtroom. The Novell issue we filed for, basically we think that's going to happen more quickly. It's a very simple issue. Preliminary and permanent injunctive relief we filed for there. We expect that one will probably come in ahead of the IBM decision. And then as far as these end user cases that we're talking about, we don't know yet. I mean, you should expect to see, Boyce basically said we would have these filed by February 18th. And from what I can see right now, that's probably, I expect that that's what's going to happen. So in the end, what happens to this SCO company? So we started off talking about this big, giant, David Goliath battle. It's turned into a much bigger, more intense issue with thousands of people around the world, many here in this room that are not particularly pleased with our company. We are working through these issues. We feel like we have very strong property rights. We feel as strongly that our property rights are being stepped on and violated as many people here feel, these SCO guys are coming after our free work. I'd like to dispel one thing right now, that we're not, I repeat, not trying to go after the legitimate contributions that Linus, maybe some of you in this room, or people around the world, or even legitimate contributions that IBM has made. We are going to fight extremely hard until we get what we think is the justice due us to the things that we think are being violated against our rights. As in the Super Bowl parlance, you win the Super Bowl or you lose, it's a big difference. I read a study a while ago that communities where the team wins the Super Bowl, the following year, the morale of the whole city is higher and violent crime is lower. Particularly domestic violence crime goes down.
So look forward to a good year.
So look forward to a good year here in the Boston area. it was pretty interesting that one thing could have such a big impact on a community. I would expect similar things here. I think the winner of this case, one way or another, it's going to be a big win. And so we look forward to having our case tried through the court system. Obviously, for us to win this, it would be a huge deal. And, you know, so that's what we're fighting for. We're going to, again, go through the court system, look forward to the results. We feel confident in our claims. But just like the Super Bowl, you got to go to the game and play to see what's actually going to happen.